In this lesson, what we're going to do is continue to talk about the concept of parliamentary sovereignty and some of the potential implications which can be had in relation to said concept. And this involves us having a conversation about the idea that exists within sort of broader constitutional theory relating to the idea of constitutional statutes. We're going to talk in this lesson about what constitutional statutes may be, how they may represent something of a limitation on parliamentary sovereignty, at least a limitation on the doctrine of implied repeal, and then have a little look at some of the case law which tries to establish this principle. So, oopsie daisy. So, like I said, this lesson is going to spend some time examining one of the principles of the UK Constitution, which implies the existence of a hierarchy of statutes which may be passed by Parliament. And traditionally, we understand that this may represent something of a limitation on the principle of parliamentary sovereignty, because one of the things that the idea of constitutional statutes provides is something of a significant weight to the particular piece of legislation, such that it takes more than simply something like the doctrine of implied repeal to remove it, to repeal and replace said legislation. All of which implies that the principle of parliamentary sovereignty does not have this unlimited authority in the same way as the traditional understanding of sovereignty is. So as a basic recap, if we remember back to previous lessons, we had the second Factortame case, where the House of Lords had the issue of two pieces of legislation which were potentially in conflict with each other. These pieces of legislation were the European Communities Act from 1972 and the Merchant Shipping Act from 1988. Fundamentally, the Factortame case, just skipping all the way to the end, sees that there is a contradiction between the European Communities Act in relation to a violation of EU law in relation to the Merchant Shipping Act. Now, the reason they were in conflict is because the Merchant Shipping Act violated the law of the European Union, and so violated the principle of the European Community's supremacy as stated in the European Communities Act. And so by extension of this principle, it also violated the European Communities Act. So you have something of a contradiction here. You have a piece of legislation which was passed in 1972, which is contradicted by a piece of legislation which is passed in 1988. Now, given a traditional approach to parliamentary sovereignty, and on application of the principle of implied repeal, one might think that the result would be the disregarding of the 1972 Act. If you remember back to the Vauxhall case, you remember that the legislation which was passed previously was the one that was disregarded and replaced by the piece of legislation which was passed subsequently. If we were to apply that exact same logic here, then the Merchant Shipping Act would apply over the European Communities Act. But the House of Lords decided instead to apply the former legislation rather than the latter. And so they essentially flipped on their head the principle of implied repeal. And so as a result of which, it begs the question as to whether or not we would grant, for example, the European Communities Act from 1972 some kind of special status which the Merchant Shipping Act did not have, such that even where there is a contradiction and where implied repeal may suggest that the European Communities Act be repealed, it doesn't, because of this special status which is given to this legislation. This is further discussed in the case of Thurn and Sunderland City Council from 2002. In this case, we have another example where we see legislation which challenges the European Communities Act. Specifically, this legislation is the Weights and Measures Act of 1985. According to Section 8 of the Weights and Measures Act, it specified that the use of the pound was a metric, as a metric for weight would be illegal. Okay, Mr. Thurn and others argued that the Weights and Measures Act impliedly repealed that of the European Communities Act, even though the Weights and Measures Act violated EU law and by extension therefore violated the principle of supremacy as stated in the European Communities Act. And this raises the question again. It puts the courts in quite an uncomfortable position, given the fact that you have another example of legislation which should surely impliedly repeal the European Communities Act, but of course you've got the previous examples of cases whereby you have legislation which does not repeal the European Communities Act, like the Factortame case. The court would dismiss this claim, the claim that the Weights and Measures Act impliedly repealed the European Communities Act. And they made it clear that the Weights and Measures Act could not impliedly repeal the European Communities Act. But what is more important to our argument here is it tries to give something of an explanation as to why the doctrine of implied repeal does not apply in this situation. And this is the important view which is suggested by Lord Justice Laws, who says that we should recognise a hierarchy of Acts of Parliament as if there were ordinary statutes and constitutional statutes. This gives rise to this question about constitutional statutes, and also this question of there being a hierarchy of legislation. What Lord Justice Laws says here, and we're suggesting here, that there should be some special class of legislation which could be considered of having the status of being quote-unquote constitutional in nature, and so the result of which may imply that the doctrine of implied repeal cannot be utilised in relation to these pieces of constitutional statutes, given the fact that if that was the case, then you would see a repeal of the European Communities Act. You'd probably see repeals of the Human Rights Act and the Constitutional Reform Act, etc., etc., etc. And so in relation to this, they make the argument that rather than allowing the legislation which is constitutional in nature to be repealed impliedly, in order for Parliament to change the law in that regard, it must expressly make it clear that that is their intention to do so. So it has to pass legislation which repeals the previously constitutional statute, rather than just impliedly repealed by way of contradiction. This suggests, therefore, that the doctrine of parliamentary sovereignty is not one which is completely unlimited, or at least that the principle of implied repeal is not completely unlimited. Parliament still has the ability to make and unmake any law they so choose. They could still repeal the European Communities Act, which they have done post-Brexit, but they don't do so, but they can't do so by implied repeal. So it suggests that parliamentary sovereignty is still safe, but this specific element of parliamentary sovereignty may not be. And so this may ask the question, okay, well, what are constitutional statutes? Well, this is where Lord Justice Laws cites further conditions. He says that there are conditions which could be given to an Act of Parliament to give them this certain degree of constitutionality, this view of having some kind of constitutional status. They say that the legislation conditions the legal relationship between citizen and state in some general overarching manner, or enlarges or diminishes the scope of what we would now regard as fundamental constitutional rights. This is something of a relatively broad and overarching interpretation, but it gives us some idea of what kinds of pieces of legislation may be fit into this category. And I've cited some of them here. This is a non-exhaustive list because there are others that can be argued, and really it is up for the courts, and it is up for those who are either claimants or defendants in cases to essentially make the argument that the legislation is constitutional in nature. So it is up to the courts to essentially make this determination as to which statutes may be constitutional and therefore may be granted protection against implied repeal through this precedent established by Thurn. So, for example, Lord Justice Laws suggests the Magna Carta from 1215, the Bill of Rights from 1869, the Acts of Union, the Government of Wales Act, the Scotland Act, the European Communities Act, the Human Rights Act, all contribute to being constitutional statutes. And we can understand why, because they fundamentally deal with one of the two conditions that are cited in the previous slide. So if you think about it, they condition the legal relationship between the citizen and the state in some general overarching way, or they enlarge or diminish the scope of what we call human rights. Well, if we look at all these pieces of legislation, the human rights condition can be established by the Human Rights Act, by Magna Carta, by the Bill of Rights to an extent. Things like the Acts of Union, Government of Wales Act, Scotland Act, all relate to things pertaining to the internal domestic understanding of the United Kingdom. So, for example, devolution with the Government of Wales Act and Scotland Act. This constitutes a relationship between the citizen and the state. So too does the European Communities Act, which not only constitutes a relationship between the citizen and the state, in that the citizen can then rely on the law of the European Union, but it can also be argued that it contributes to the enlargement of fundamental rights, owing to the fact that membership to the European Union also includes membership to the Fundamental Charter of Human Rights.